You've seen those jaw-dropping courtroom moments on TV, right? A surprise witness appears out of nowhere, a last-minute tearful confession, or a lawyer dramatically exposing some dark secret from the defendant's past. I mean, it makes for incredible television, but how much of it is real? Well, in this explainer, we're going to pull back the curtain on the real rules of evidence and separate the Hollywood fiction from the courtroom fact.
So let's start with this classic scene. Picture it. A prosecutor turns to the jury, points a finger, and says, "Ladies and gentlemen, the man on trial for this robbery has robbed 10 banks before." It's a total TV trope, but could that actually happen in a real American courtroom? Well, the answer might surprise you. It's a lot more complicated than you'd think.
See, here's the thing. Unlike the chaotic free-for-all you see on TV, real courtrooms are governed by a very strict set of guidelines called the rules of evidence. You can think of it as the official script for the trial, and its whole purpose is to make sure that a verdict is based on solid, reliable facts, not on drama, not on prejudice, and definitely not on surprise attacks. So let's bust a few of the biggest myths you see on screen.
Okay, first up, that classic TV scene where some random character just waltzes onto the witness stand to say whatever they want. In the real world, it just doesn't work like that. There are very specific rules about who is even allowed to speak, which brings us right to our first myth.
The absolute #1 most important rule for a regular witness, we're not talking about experts here, is that you must have personal knowledge. What does that mean? It means you had to have directly seen it, heard it, or perceived it yourself. You can't get up there and talk about what your neighbor told you or what you think probably happened. Bottom line, you had to have been there.
Now, this is where it gets really interesting. Look at who actually qualifies. As long as you have that personal knowledge, you can be a witness. Heck, even a child can testify, as long as they can show they understand the difference between telling the truth and telling a lie. But look who can't. The judge running the trial and the jurors who are deciding the case. They are absolutely forbidden from becoming witnesses in a trial they're a part of.
Okay, let's circle back to our TV prosecutor and that bombshell about the defendant's criminal record. This brings us to myth #2. And honestly, this is probably the biggest and most common misconception of them all. This idea that a defendant's shady past can be used to prove they're guilty now.
So here's the crucial point. The law generally forbids what's known as character evidence. A prosecutor can't just bring up past mistakes to show that a defendant is a bad person and is therefore more likely to be guilty of this crime. And why is that? Because it's considered incredibly prejudicial. The fear is that a jury might convict someone based on their past, not on the actual evidence for the crime they're on trial for today.
And this quote just perfectly sums up the logic. A person has to be tried for their actions in this specific case, not for who they were or what they might have done years ago. The system is designed to prevent a jury from thinking, well, they seem like a bad person, so they must have done it, and just ignoring the actual evidence. But, and this is a huge but, here's the critical exception. While you can't attack the defendant's character to prove they're guilty, you can attack a witness's credibility to show they might not be believable. This is called impeachment, and here's the twist. If a defendant chooses to get on the stand and testify, they become a witness. And at that moment, the rules can change. Suddenly, certain past actions, especially ones related to honesty, might just become fair game for the prosecution to bring up.
Now for our third and final myth, one you've definitely heard screamed on TV 1,000 times. Objection! Hearsay! It's probably one of the most famous legal terms out there, but it's also one of the most misunderstood. So what does it actually mean? Yeah, it's one of those words that gets thrown around all the time. Is it just gossip? Is it something you heard on the street? Let's clear this up once and for all.
Okay, here's the technical definition. Hearsay is any statement that was originally made outside of the courtroom, which is now being brought into the courtroom to prove that what the statement says is true. Basically, it's trying to use he said, she said as actual evidence.
And the whole reason hearsay usually isn't allowed is pretty simple, actually. It's because the person who originally said the thing isn't on the witness stand. You can't cross-examine them. The other side can't challenge their memory, look them in the eye, and test whether or not they were telling the truth. Since you can't test its reliability, it's generally out.
But, and believe me, this is a big but, there are dozens of exceptions to the hearsay rule, and some of them are incredibly dramatic. Take the excited utterance. That's a statement someone blurts out during a shocking event, like yelling, "The car just ran the red light," as it happens. The law basically assumes you don't have time to make up a lie in that moment. And even more dramatic, the dying declaration. If someone truly believes they're about to die, their statement about what caused their death can sometimes be heard by the jury. It's based on this very old idea that nobody wants to meet their maker with a lie on their lips.
So, after all these rules, myths, and exceptions, what's the big picture here? Why does the legal system go to such incredible lengths to filter what a jury actually gets to hear?
Well, these rules are really the gatekeepers of justice. They aren't just technicalities to trip lawyers up. They exist to make sure a person is judged on the specific facts of this case, supported by reliable, testable evidence. They protect against bias and make sure the trial stays focused, fair, and just. It's really the system's way of separating the signal from all the noise.
And that really leaves us with this final crucial question. Our legal system has basically decided that the answer is no, that a fair process is actually more important than an information free-for-all. It's this constant balancing act, right? Letting in enough evidence to get to the truth while filtering out anything that could lead a jury to the wrong conclusion for the wrong reasons. And that debate, well, that lies at the very heart of our search for justice.